and platting issues, but I took that risk to buy the house. I was very cordial with the seller of the house and lent him a couple of my guys to move his personal effects out of the house. And that way I could ensure that I had a clean slate to work with. There was a lot of personal effects in the living room that would hinder my ability to do my job. After a couple of times that I sent my guys and the seller of the house under the lease back, rescheduled them, I stopped sending them and stopped being so nice. And then when he moved out on the 14th, I went over there and all of his personal effects were gone, yes. But all the construction material inside the house that was meant for that house was not there anymore. We had previously had a conversation with John Dara, the realtor, and Mr. Open that those construction materials stayed with the house. I mean, the office door was a strange measurement and it was framed accordingly, and it was very uncommon in the building world. So that let me know that those pieces were meant for that house. That was my whole issue. And then come to find out when I go to permitting that the seller had told some mistruths about the platting, permitting, and where it stood with the city of Dallas. So at that point, I decided not to give him back the lease deposit because it would cost me, it ended up costing me about $45,000 to replace all the items that he took out of the house. And then it cost me an additional $11,000 to get it replatted and permitted with the city of Dallas, which I did. And I mean, that's where I stand on the matter.
I know that Mr. Schutze is testifying via narrative, but I'm going to have to object to the amounts that it costs to replace these items that he's alleging my client took. He has no personal knowledge or no standing to even claim or be able to evaluate the property because they weren't his property. It wasn't his property. It was my client's property. So he shouldn't be able to testify to the value of those items.
Was this your property or was this the plaintiff's property?
Originally, it was the plaintiff's, and then I purchased it from him. But he has a list in Exhibit 1 listing all the things that were in discrepancy. And the AC unit alone cost me $22,000 to replace that. The tubs were $1,200 a piece. Sinks were $650. I mean, there's a real dollar figure for everything on the list that your client put in Exhibit 1.
Well, Judge, I have to object to it because the items that he's describing were and still are.
I think your client provided a list of the value of the items that he took. I think Mr. Schutze is providing testimony about the replacement cost of what he spent to replace the items that were took, as I understand it. Is that right, Mr. Schutze?
That's correct. Yes, Judge.
Okay. I think he can testify about that.
Okay.
All right. Anything else, Mr. Schutze?
No, sir.
I mean, do you have any other testimony?
No, I'm done at this time.
All right. Mrs. Schutze, do you have any questions at this point of your husband?
No, I don't. Thank you.
Any additional questions, Mr. Ackles?
Not for Mr. Schutze, no.
All right. Ms. Schutze, it's your turn. I'm sorry, were you going to call Ms. Schutze?
Yes, Judge, please.
Ma'am, you need to raise your right hand.
Mhm.
Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may proceed.
Hello, Ms. Schutze. How are you?
I'm good. How are you?
I'm fine. I've got a couple questions for you. One, were you an owner of Madison Green Investments, LLC?
Sorry, you cut out at the beginning. I just heard the end of what you said.
That's okay. At the time that this property was sold back in 2018, were you an owner of Madison and Green Investments, LLC?
I'm not sure. I'm not sure. I'm so sorry.
Is there a possibility that you were?
Yes. Yes.
And this Madison Green Investments, LLC was created in 2018, correct?
Mhm.
And you and your husband were married back in 2012, right?
Yes.
This entity was created while you and your husband were married.
Uh-huh.
And then I have the same question for Schutze Signature Homes, LLC. At the time that this contract was entered into, were you an owner of that LLC?
No.
Are you currently an owner of Schutze Signature Homes, LLC?
Wait, I'm sorry. Hang on. Shootsy signature. To answer your previous question, I am not sure if I am an owner on that business or if I was back then.
Is there a possibility that you were, though, at the time?
Yes.
Is there a possibility that you're currently an owner?
Yes.
Is there a possibility that you're currently an owner of Madison Green Investments, LLC?
Possible. Yes. Possibility. Yes.
And,
You cut out that whole thing. I'm so sorry.
okay. Schutze Signature Homes, LLC was also created in 2018, correct?
I think so. Mm-hmm.
And that was, and we've been through this, but in 2018, you and your husband were married at that time and are continuing.
Yes.
Both of those entities were created at the time that you and your husband were married.
Yes.
And there's a possibility that at the time the contract was entered into, you were an owner of both of those entities, right?
Mm-hmm.
And there's a possibility, is that a yes?
Ma'am, you have to
Yes.
answer out loud.
Yes.
Okay. And there's also a possibility that you're currently an owner of Madison Green Investments, LLC.
Yes. Yes.
That's all I have for Ms. Schutze.
Mr. Schutze, would you like to ask your wife any questions?
Yes, I would.
Go ahead.
Oh, did you sign the contract for Jamestown when it was with Fairview?
Did I sign it?
Yeah.
Oh,
These are
honey.
closing documents on that.
I don't know. No. Yes. I don't know.
Okay, no further questions.
I'm sorry.
It's okay.
I'm not
Anything-
prepared. I'm sorry.
It's okay. Any other questions for Ms. Schutze? Mr. Ackles?
Nothing for me, Judge.
Okay, Ms. Schutze, that's the end of your testimony for now. So, Mr. Ackles, do you have any other witnesses?
Yes, Judge, I'd just like to call myself in regards to attorney's fees.
Please raise your right hand. Do you swear or affirm the testimony about to give shall be the truth, the whole truth, and nothing but the truth? Did you say yes?
Yes, Judge. Okay. Your Honor, my name is Gregory K. Ackles, Jr. I am a member of the Dallas law firm of Ackles and Ackles, LLP. I am an attorney licensed to practice law in the state of Texas and have been licensed by the Supreme Court of Texas since 2018 to practice law in the state of Texas and I've continually practiced law in Dallas County, Texas since my licensure. I'm familiar with the fair, reasonable, necessary, and usual and customary fees charged by attorneys in Dallas County, Texas for handling matters such as the instant lawsuit. Legal services rendered in connection with the representation of my client, Mr. Charles Opheim, in this lawsuit included drafting and preparation of plaintiff's motion for new trial and First Amendment petition, legal research and briefing, conferences with my client, witnesses, and attorneys, exhibit preparation, preparation for trial, and appearance today for final trial, as well as other activities appropriate to this lawsuit. In rendering legal services on behalf of Charles Opheim, my client, in this action, I have expended, including today's time, 20 and a half hours of my own time. Other members of the law firm have expended 18.4 hours of time on this case. A reasonable and necessary attorney fee for the services rendered by me is $250 an hour, and reasonable and necessary attorney's fees for the services rendered by other attorneys in my firm, in this firm, are $350 an hour. The time, labor, and expenses incurred and expended on behalf of my client, Charles Opheim, in connection in this lawsuit were reasonable and necessary, given the novelty and difficulty of the questions involved, the requisite skill to perform legal services properly, the experience, reputation, and ability of the lawyers performing the services, and the amount involved. I have an opinion as to the amount of the fair, reasonable, and necessary attorney's fees for legal services rendered by me and my firm in connection with handling of this lawsuit in the trial court, as well as legal services to be rendered in the event this case is appealed. My opinion is that $11,565 is fair, reasonable, and necessary attorney's fees for the services rendered by me and my firm, the trial court, in a matter of this kind and magnitude in Dallas County, Texas. And said services were reasonable and necessary for proper representation of the client in this matter. In addition to my testimony, I'd like to refer to Plaintiff's Exhibit number 9, which has been previously admitted. These are statements of legal services from my firm that have been sent or that have been created by my firm in pursuit of my client's claims. These statements were created by my firm and myself in the ordinary course of business, and these statements were sent out to my client in the ordinary course. I asked the court to take notice of Plaintiff's Exhibit 9 in considering this this plea for attorney's fees. And thank you, Your Honor. That's all I have.
So your total attorney fees you're asking is $11,565, and then appellate, did you say? I didn't think I may have missed that.
I just stated for appellant fees, or I didn't put a number on there, Judge.
Okay.
But yes, the total amount I'm asking for is $11,565.
Okay. Any cross-examination, Ms. Schutze? Need to unmute you.
I'm sorry, can you? No,
Do you have any questions for Mr. Ackles?
I don't.
Mr. Schutze, do you have any questions for Mr. Ackles?
No.
All right. Mr. Ackles, call your next witness.
Your Honor, at this time, I have no more witnesses and plaintiff rests.
All right, Mr. Schutze, call your first witness if you have one.
I don't have any.
But this would include if you want to give any additional testimony now.
No, I rest my case, Your Honor. Thank you.
Mrs. Schutze, do you have any, call your first witness.
I don't have any.
Do you rest?
I do.
All parties rest and close.
Yes, Your Honor.
Yes.
Yes, Your Honor.
All right, we're going to now do closing arguments. Mr. Ackles, one thing I do want you to concentrate on, you have 5 minutes each, is I don't see how Mrs. Schutze is involved in this at this point, or that you've met your burden of proof on that issue. So you need to point to me evidence maybe that I haven't seen or I haven't noticed to establish that. But otherwise, just go forward with your opening. Ms. Ablon, can you go ahead and keep time for each party? They each have 5 minutes. And go ahead and announce, you can unmute Ms. Ablon, and you can give them a countdown from 1 minute, 30 seconds, and then time is up.
Okay.
Mr. Ackles, you have 5 minutes.
Thank you, Your Honor. Your Honor, I think it's clear today that the evidence showed that the only breaching party in this case are the defendants. We've already established that the two entities involved in this case, the two defendant entities, Madison Green Investments LLC and Shoots Signature Homes LLC, failed to make an appearance today. And
Mr. Ackles, one other thing I want you to talk about is, and maybe share screen it, is what basis you have to treble damages here, because I know that you cited to something, but I'm not familiar with that statute, so you'll need to share screen that. But go ahead.
Okay. Like I was saying, Your Honor, I think we've established that the two entities have failed to make an appearance today, and we've asked the court to strike their pleadings, their answers in this case, and enter a default judgment against them. That being said, we also believe that the evidence shows that the two individual named defendants, Mr. Nolan Schutze and Ms. Hope Schutze, are also individually liable in their individual capacity for the damages suffered by my client today. The sales agreement was entered into by the parties, which included a lease agreement for a 2-week period. Originally,
Mr. Ackles, did Ms. Schutze sign any of the documents in this case?
Not that I know of, Judge.
Okay.
And we believe the security deposit was changed.
What is the statutory basis for treble damages? Can you show me that?
Yes, Judge. Well, I don't know if I can show it to you, but I have the statute, the property code statute in front of the numbers in front of me.
I don't know if I don't have the property code here.
Okay, I can give you the number.
Can you give me the number? Mackenzie, can you go ahead and look that up on Westlaw, the number he's about to, it's Texas property code. What is the number?
There, it's 92.103. I'm sorry, Judge, specifically for the 3 times damages, it's 92.109 A through D.
A through D. Okay. Ms. Malloy, if you could go ahead.
None of that statute, Judge. It says if a landlord.
Want me to share screen it?
Yeah, if you could share screen it, that'd be great.
I'll stop sharing mine.
And I stopped the timer, correct?
No, keep going.
Okay.
Can you see it?
Yes.
Let me see.
May I continue, Judge?
Okay. Yeah. Let me see the beginning of that. Let me go back a little bit. That's very good, though, Ms. Malloy. Thank you for doing that. But can you move up a little bit on it?
Yeah.
I mean, I want to see the beginning of it, like before A. Oh, is that where it starts?
Yeah.
Okay. All right. Leave that up because I'm going to want to talk to Mr. Schutze about it as well.
So, Judge, we believe that the evidence showed clearly that the landlord, in this case, Mr. Schutze, who acknowledged that he himself was the landlord in his testimony and that he himself received the $10,000, he has acted in bad faith by refusing to return the $10,000 within the 30 days after my client demanded it, and also refusing to provide an accounting and itemized deduction from the security deposit, the amounts that he was refusing to return to my client. So by doing those actions under the statute of the Texas Property Code, he has acted in bad faith, which means my client is entitled to 3 times.
So you look at Section A and Section B. Section A says if he bad faith retains the security deposit, and then he goes on to the next portion, which is, are you relying on the next portion as well? Who in bad faith does not provide a written description, itemized list of damages and charges in violation of this subchapter, forfeits the right to withhold. Are you relying on that as well?
Yes, Judge. I'm relying through the full A through D of this statute, and that the landlord, Mr. Schutze, has violated this, and that is why my client is entitled to 3 times the security deposit amount plus $100 plus all of his reasonable and necessary attorney's fees. We believe that the evidence clearly shows that today. We believe that the contract for sale did not include the construction materials that Mr. Schutze has claimed my client wrongfully took. All of the things that my client took were his property, his personal property, in compliance with the lease agreement. He took nothing in terms of fixtures, anything that was permanently attached. It's the only thing that the sales agreement covered, and by that there is no breach from my client. The defendants have no claims that they've met their burden on. They've pled for breach of contract and conversion and misrepresentation. They've produced no evidence that supports those claims. They have not met their burden. In fact, the evidence is so greatly in favor of
So, Mr. Ackles, it says here under 92.109 subsection D, and Mr. Schutze, you should be reading this all very carefully. A landlord who fails either to return a security deposit or to provide a written description and itemization of deductions on or before the 30th day after the tenant surrenders possession is presumed to have acted in bad faith. Is that, you're relying on that as well, I assume, right?
Yes, Judge. He's presumed acting in bad faith, and he's provided no evidence to the contrary to rebut that presumption.
Wow. Okay.
And that is why my client is
30 seconds.
entitled to these damages. He is not liable in any capacity. This was the agreement. Whether or not Mr. Schutze signature appeared on that document that he looked at during trial, it's clear that both parties performed. Mr. Schutze did receive the $10,000. He did get the benefit of that contract. He did not dispute that. It is not in dispute that my client did not comply with his obligations under the lease contract by moving out on time and getting his property out. There was an agreement. Any way you slice it, there was an agreement. My client complied with it. Mr. Schutze failed to, and is he clearly in breach of it. We ask that the court find that the defendants do not recover in any amount under any of their claims. We believe that the evidence did not support them meeting their burden on any of their claims. There has been no document produced by Mr. Schutze regarding any documentation on how his damages are calculated. Nothing has been provided. The only
Time's up.
Okay, and we just ask that you grant the damages that we plead for, Judge.
Mr. Schutze?
Yes, Judge.
Your closing argument, and I would look at that. You can see the screen, right? This is the law that we have to obey.
Correct. Sorry, Judge. I'm looking for the email that I sent Mr. Charles Ofrim telling him that he was not going to receive his deposit and why. And that was within that time period.
What exhibit number is that?
I did not submit it to the court. Can I use it in this or no?
Unfortunately, in the closing arguments, you can only rely on the testimony that's been given and the exhibits that have been admitted.
Okay.
Is it part of maybe their emails that they sent that they admitted? Because you can use their
They didn't admit these emails. It was on my last lawsuit with Mr. Ofrim that they were submitted. But to be honest, I wasn't prepared for this trial. So there it is. So closing arguments, I asked the court to at least take my wife off of this lawsuit since she had nothing to do with it. She wasn't even a part of Schutze Signature Homes at the time. She signed no documents and was in no part of any of the organizations or negotiations of this. I asked the court to look at both sides and see that when I bought a property, I was expecting to get the AC unit and the bathtubs and all the fixtures that were inside the property at the time of purchase, thinking that they would be part of that property. I did let Mr. Ofrim know that he wasn't going to receive his deposit, and then shortly after that, I got a legal demand letter. It is a lot of he said, she said in this argument, and I don't think that he should get his deposit back or the 3 times on this. I don't know. I got nothing else to say on it.
Mrs. Schutze, do you have anything else?
Are you asking me?
Yeah, it's your turn for your closing argument.
I have nothing to say.
Okay. Would you like, Ms. Schutze, are you stipulating that you're part of this and that the judgment should be against you, or are you objecting to the judgment being against you?
I had nothing to do with this. So that's why I'm limiting what I say, because I really know little to nothing. So that's where I'm at here.
Okay. All right. So I'll go ahead and render judgment. Mr. Schutze, you know, this is unfortunate. I have to follow the law. This seems like kind of an extreme law. I've never dealt with this section of the property code. I admire that you want to try to do things on a handshake deal. It's admirable, but sometimes it can come back and bite you, as this case I think it has. And so that being said, I'm going to unfortunately have to award $10,000 in damages for the failure to return the security deposit. And under this property code section, the presumption is that if there was not a return of the return of the security deposit that or a written description provided, neither of which was submitted to the court, the presumption is that the landlord acted in bad faith. Mr. Schutze, you were a landlord at this time. You didn't, so it was your presumption, it was your burden of proof to show that you didn't do this, and you failed to do that. So I'm going to have to order treble damages. So it'll be $30,000 against both of the corporate entities as well as against Mr. Schutze. I agree. By the same token, Mr. Ackles, it was your burden of proof to show that Mrs. Schutze was somehow connected to any of this, and I didn't see any evidence she was in any way connected to this, or even that it was your burden of proof to show that she was one of the owners of these companies. She doesn't recall, and there was no evidence to the contrary. So you failed to meet your burden of proof. So Ms. Schutze, you are not going to have a judgment taken against you in this case. For the attorney's fees, the court is going to award attorney's fees of $11,565 as well, and appellate fees of $5,000 for an appeal to the Dallas Court of Appeals, and $10,000 if there's an appeal to the Supreme Court. Is there anything else?
Your Honor, do you want me to draft this up in a final judgment and send it to you?
I want you to prepare a judgment. I want you to share it with Mr. Schutze. Ms. Schutze, since you're not part of the judgment, do you want to see the judgment before it's sent to me, or are you okay with your husband looking at it?
I'm okay with him looking at it. Yes.
So you waive your right to look at it before it's submitted?
Yes.
Okay.
Because
All right.
I'm no longer a part of this, right?
Well, at this point, yes.
Okay.
And I have found that you are not a part of it. Mr. Ackles could conceivably appeal that, and then we'd have to go from there. But my finding is that you are not a part of this.
Okay.
So does that change your mind about wanting to look at the judgment before it's submitted?
It does not, no.
And Mr. Schutze, you're welcome to share it with your wife if you feel like you need to.
Okay. Thank you, Judge.
All right. Anything else, guys?
You want me to send that to Rhonda, or do you want me to e-file it, or both?
Both, and make sure you run it by Mr. Schutze. Mr. Schutze, you'll have 3 business hours to review that and return it. I'd like to get it before Thursday if possible.
Okay. 3 hours or 3 days?
3 hours.
Okay, no worries.
Okay.
Thank you, Judge.
Okay. Anything else?
Nothing for me, Your Honor.
All right. The court is going to go ahead. Mr. Schutze, anything else from you?
No, sir.
Mrs. Schutze?
Nothing from me, no.
I'm going to go ahead and stop the live stream, and you guys may go forth. Thank you so much.
Thank you, Judge.
Thanks.